and the Violent Crime Control and Law Enforcement Act of 1994 to reauthorize the Missing Alzheimer's Disease Patient Alert Program.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentlewoman from California, Ms. Waters, each will control 20 minutes. The Chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 2800 as amended, currently under consideration.
Without objection, adopted.
Mr. Speaker, I yield myself such time as I may consume.
You gentlemen recognized.
Mr. Speaker, H.R. 2800, the Missing Alzheimer's Disease Patient Alert Program Reauthorization Act of 2012, is sponsored by the gentlewoman from California, Ms. Waters. I thank her for her work on this issue. Alzheimer's disease is a serious condition that is becoming more and more prevalent. The disease affects as many as 5 million people in this country, or 1 in 8 older Americans, and a new person develops Alzheimer's every 69 seconds. This pace is expected to increase with time. It is estimated that more than half of the people with Alzheimer's or other types of dementia will become lost from their families or caretakers at some point. Many of these people cannot remember their name, their family members, or their address. This makes returning home safely difficult for law enforcement officers and Good Samaritans. As is true whenever a person goes missing, time is of the essence when attempting to locate a lost Alzheimer's patient. One study found an almost 50% mortality rate for Alzheimer's patients who are not found within 24 hours of becoming lost. To address the problem of missing Alzheimer's patients, Congress created the Missing Alzheimer's Disease Patient Alert Program in 1996. This Justice Department program provides grants to locally based organizations to protect and locate missing patients with Alzheimer's disease and related dementia. Congress has appropriated money for this program every year since its creation. The Justice Department has provided grants to several programs, including the Alzheimer's Association's Safe Return Program. In this program, people with Alzheimer's and dementia are registered in a database and receive a bracelet that indicates the individual is memory impaired. The bracelet also includes a 24-hour emergency response number to call if the person is found wandering or has a medical emergency. The Alzheimer's Association reports a 99% success rate for reuniting enrolled missing individuals with their caretakers through the Safe Return Program. H.R. 2800, the Missing Alzheimer's Disease Patient Alert Program Reauthorization Act of 2012, reauthorizes this program at $1 million a year for 5 years. This authorization level reflects the fiscal year 2012 appropriations level. H.R. 2800 helps to ensure that people with Alzheimer's disease and other forms of dementia are returned safely home when they become lost. Again, I want to thank the gentlewoman from California, Ms. Waters, for her leadership on this issue, and I encourage my colleagues to join me in support of this bill, and I'll reserve the balance of my time.
Gentleman reserves. The gentlelady from California.
Mr. Speaker, I yield to myself such time as I may consume.
Gentlelady is recognized.
I thank Chairman Lamar Smith for his support for H.R. 2800, the Missing Alzheimer's Disease Patient Alert Program Reauthorization Act. This bill reauthorizes a small but effective program that assists local law enforcement and protects vulnerable people with Alzheimer's disease. I appreciate the Chairman's willingness to work with me and move this bill forward. Alzheimer's disease currently affects an estimated 5.3 million Americans, and that number will multiply in the coming decades as our population grows. The Alzheimer's Association estimates that 7.7 million Americans will have Alzheimer's by the year 2030, and 11 to 16 million Americans will have the disease by the year 2050. One great risk for Alzheimer's patients is wandering away from home. According to the Alzheimer's Association, more than 60% of Alzheimer's patients are likely to wander. Wanderers are vulnerable to dehydration, weather conditions, traffic hazards, and individuals who prey on vulnerable seniors. Up to 50% of Alzheimer's patients who wander will become seriously injured or die if they are not found within 24 hours of their departure from home. Wanderers often cannot remember who they are, where they live, and cannot assist law enforcement officials and other first responders who try to help them. The Missing Alzheimer's Disease Patient Alert Program is a Department of Justice program that provides competitive grants to nonprofit organizations to assist in paying for the cost of planning, designing, establishment, and operating programs to protect and locate missing patients with Alzheimer's disease and related dementias. These grants help local communities and public safety agencies quickly identify persons with Alzheimer's disease who wander or who are missing and reunite them with their families. The program was originally authorized in 1996, but it has been operating under an expired authorization since 1998. H.R. 2800 reauthorizes the program and authorizes $1 million per year in appropriations for fiscal years 2013 through 2017. This authorization level will allow the program to continue to operate at the funding year 2012 funding level for the next 5 years. This program is extremely cost-effective. An annual appropriation of simply $1 million could easily result in millions more in savings for the federal government by allowing more Alzheimer's patients to remain at home with their families, thereby reducing nursing home utilization and saving Medicare and Medicaid expenses. H.R. 2800 is co-sponsored by 18 members of Congress, including Congressman Chris Smith and Congressman Ed Markey, the co-chairs of the Bipartisan Congressional Task Force on Alzheimer's Disease. The bill is also supported by both the Alzheimer's Association and the Alzheimer's Foundation of America. This program saves law enforcement officials valuable time and allows them to focus on other security concerns. It also reduces unintentional injuries and deaths among Alzheimer's patients, brings peace of mind to their families, and thus allows more Alzheimer's patients to remain at home with people who love them. So I urge my colleagues to support this bill, and I would reserve the balance of my time.
Gentlelady reserves. Gentleman from Texas.
Mr. Speaker, we have no further speakers on this side, so we'll reserve the balance of our time as well.
Gentleman reserves. The gentlelady from California.
I have no further requests for time. I would
Does the gentlelady yield back?
The balance of my time.
Gentlelady yields back. Gentleman from Texas.
Mr. Speaker, I'll yield back the balance of my time as well.
Gentleman yields back. The question is, will the House suspend the rules and pass H.R. 2800 as amended? Those in favor say aye. Those opposed, no. In the opinion of the Chair, 2/3 being in the affirmative, the rules are suspended. The bill is passed, and without objection, the motion to reconsider is laid on the table. Purpose does the gentleman from Texas rise?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 6185, Local Courthouse Safety Act of 2012, as amended.
The clerk will report the title of the bill.
H.R. 6185, a bill to improve security at state and local courthouses.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentleman from Virginia, Mr. Scott, will each control 20 minutes. The Chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 6185 as amended, currently under consideration.
Without objection.
And, Mr. Speaker, I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, first of all, I'd like to thank our Judiciary Committee colleague, Ms. Adams of Florida, for her work on this issue to make America's courthouses safer. This bipartisan, bicameral bill passed the Senate Judiciary Committee by unanimous consent last May. And before I yield to her, I do want to urge my colleagues to support this bill and thank Ms. Adams again for all of her work that brought us to this point we are here today. And I will yield the balance of my time, as much time as she might consume, to the gentlewoman from Florida, Ms. Adams.
Gentlelady is recognized.
Thank you, Mr. Speaker. I rise today in support of H.R. 6185, the Local Courthouse Safety Act of 2012, because it will give local courthouses the resources to enhance their security and to do so at no cost to the federal taxpayer. My bill would allow for surplus metal detectors to be provided to local courthouses to enhance security. Like other regions throughout our nation, Central Florida has seen its share of courthouse attacks. Shortly before I joined the Orange County Sheriff's Office as a deputy sheriff, a courthouse shooting occurred. An armed gunman by the name of Thomas Provenzano walked into the Orange County Courthouse with a 12-gauge shotgun, an assault rifle, and a revolver, .38 caliber revolver, all loaded with live ammunition. Bailiff William Wilkerson, a 60-year-old veteran who retired from the Navy as a lieutenant commander, was killed on that day. Bailiff Harry Dalton, a 53-year-old father of 6, was shot in the face and left paralyzed from the shooting. He died 7 years later. Correctional Officer Mark Parker was only 19 years old at the time of the shooting. He survived the shooting but was paralyzed from the shoulders down and had to spend the rest of his life confined to a wheelchair. I introduced the Local Courthouse Safety Act because the things this bill does are important to me and to most Americans. I know the families of Bailiff Dalton and Bailiff Wilkerson who lost their lives as a result of the violence that day in the Orange County Courthouse and remain friends with Officer Parker until he passed away a few years ago. And I am deeply aware of the grief they've had to live with all of these years. Since September 2010, there has been about 1 shooting per month at a local courthouse. So even though the shooting in Orange County happened 30 years ago, courthouse shootings are still happening all over this country, and innocent people are still dying. Those who are exercising their constitutional right of seeking justice in our courtrooms should not have to fear for their safety, and neither should our law enforcement officers, judges, advocates, and court personnel. It is my hope that this bill will help prevent horrific and senseless incidents of violence like this from happening in our local courthouses. I want to thank my colleagues on the Judiciary Committee for recognizing that we need to take courthouse security seriously and for joining me in this bipartisan effort to help prevent violence in local courthouses across this country. We need to give sheriffs and local courthouses access to the training, equipment, and resources they need to improve security. So I urge support for the bill and yield my time back to the Chairman. Thank you, Mr. Speaker.
Gentlelady reserves. Gentleman from Virginia.
Thank you, Mr. Speaker. Mr. Speaker, I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, I rise in support of H.R. 6185, the Local Courthouse Safety Act. This measure will provide critical assistance to state and local governments to provide courthouse security. But to begin with, many state and local courthouses face serious security challenges. Serious violence often occurs at these facilities, but many courthouses across the nation still lack basic security protections such as metal detectors. H.R. 6185 responds to this critical problem by giving sheriffs as well as state and local courthouses access to training, equipment, and other resources to help them improve security. H.R. 6185 accomplishes these goals by making use of existing resources. This legislation requires the General Services Administration to make available to state and local courts at no cost except for shipping, handling, and maintenance surplus security equipment that is used to detect weapons such as metal detectors, wands, and baggage screening devices. To qualify to receive such equipment, a state or local courthouse must simply have less security equipment than necessary to meet the security needs of that courthouse. Because these devices are surplus and not otherwise being utilized by any federal agencies, it is a wise use of taxpayer money to allow this equipment to be put into service at the state and local level. Another important aspect of the bill is that it expands the scope of grants awarded by the State Justice Institute to include improvement of the safety and security of state and local courts. As a result, H.R. 6185 strengthens the Institute's current authority to award grants to support education, training, and technical assistance projects to improve the administration of justice in the state courts. This measure addresses in a meaningful and constructive way the serious security challenges that state and local courthouses face. Not surprisingly, H.R. 6185 enjoys a broad range of support, including the National Sheriff's Association, the National Association for Court Management, the Conference of Chief Justices, the Conference of State Court Administrators, the American Judges Association, the National Court Reporters Association, and the Center for Judicial and Executive Security. I commend my colleague, the gentlelady from Florida, Ms. Adams, for her work in developing the bill and urge my colleagues to support the legislation. I reserve the balance of my time.
Gentleman reserves. Gentleman from Texas.
no one else who wants to be heard on this particular bill, I'll reserve the balance of my time.
Gentleman reserves. The gentleman from Virginia.
It's my time. I yield back.
Gentleman yields back. Gentleman from Texas.
And, Mr. Speaker, I'll yield back the balance of our time as well.
All time having been expired, the question is, will the House suspend the rules and pass H.R. 6185 as amended? Those in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds voting in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid on the table. For what purpose does the gentleman from Texas seek recognition?
Okay. Let's, oh, okay. Go ahead. You're okay.
Okay. Mr. Speaker, I move that the House suspend the rules and pass H.R. 1775, the Stolen Valor Act of 2011, as amended. There he is.
The clerk will report the title of the bill.
Union Calendar Number 468, H.R. 1775, a bill to amend Title 18 United States Code to establish a criminal offense relating to fraudulent claims about military service.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentleman from Virginia, Mr. Scott, will each control 20 minutes. The Chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 1775 as amended, currently under consideration.
Without objection.
And, Mr. Speaker, I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, H.R. 1775, the Stolen Valor Act of 2011, was introduced by the gentleman from Nevada, Mr. Heck, and I want to thank him for his dedication to protect the honor bestowed on our nation's military heroes. And, Mr. Speaker, I'm going to yield as much time as he may consume to that gentleman from Nevada, the sponsor of this legislation.
Gentleman is recognized.
I thank the gentleman for yielding. Thank you, Mr. Speaker. Mr. Speaker, I rise today to urge my colleagues to join with me in protecting the honor and valor of our military heroes by passing H.R. 1775, the Stolen Valor Act of 2011. On June 28, 2012, the U.S. Supreme Court struck down the Stolen Valor Act of 2005, concluding that the broad nature of the law infringed upon the guaranteed protection of free speech provided by the First Amendment of our Constitution. The Court determined that the Act, quote, sought to control and suppress all false statements on this one subject, without regard as to whether the lie was made for the purpose of material gain, end quote. However, in concurring with the decision of the plurality, Justice Breyer stated that a, quote, more finely tailored statute that shows the false statement could significantly reduce the threat of First Amendment harm while permitting the statute to achieve its important objective that was at least material. Mr. Speaker, this is exactly what my legislation does. The Stolen Valor Act of 2011 resolves these constitutional issues by clearly defining that the objective of the law is to target and punish those who misrepresent their alleged service with the intent of profiting personally or financially. Defining the intent helps ensure that this law will pass constitutional scrutiny, while at the same time achieving its primary objective, which is to preserve and protect the honor and integrity of military service and awards. In 2006, every member of both the House and Senate clearly understood the need for this legislation and demonstrated that by unanimously passing the prior Stolen Valor Act in each chamber. Mr. Speaker, the need to protect the honor, service, and sacrifice of our veterans and military personnel is just as strong today as it was in 2006. This House has the opportunity to once again show our service members and veterans that we value the magnitude of their sacrifice, while at the same time protecting the constitutional rights that they fought so hard to protect. H.R. 1775 enjoys broad bipartisan support with 107 co-sponsors and is supported by numerous veteran service organizations, including the Veterans of Foreign Wars, the Association of the U.S. Navy, the Fleet Reserve Association, the National Association for Uniformed Services, the National Guard Association of the United States, the Association of the United States Army, the Military Officers Association of America, the Military Order of the Purple Heart, and AMVETS. I would like to thank Chairman Smith and Ranking Member Conyers for helping to move this important legislation that was reported unanimously out of the Judiciary Committee. I would also like to thank my colleague from Arkansas, Mr. Griffin, for sponsoring the substitute amendment during committee consideration. Mr. Speaker, it is only fitting that we pass this bill on the 11th anniversary of the attacks of 9/11, in recognition of the brave service men and women who have fought and died in the war to bring the perpetrators of these attacks to justice. I urge my colleagues to support H.R. 1775 and yield back the balance of my time.
Gentleman yields back. Gentleman from Virginia.
Thank you, Mr. Speaker. Mr. Speaker, I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, I rise in support of H.R. 1775, the Stolen Valor Act. It has long been a tradition in the United States to recognize those in our armed services who stand out among their peers for service to our nation by awarding them special military medals and decorations. Recipients of these special honors have often been wounded in the line of duty or have made the ultimate sacrifice. Military medals and decorations constitute a tribute as well as tangible manifestation of our nation's deep and abiding recognition and appreciation to our service members. There are, however, those who falsely claim to be recipients of these special honors. Such malicious actions denigrate the integrity of those honors to those who have legitimately received them. In response, a law was enacted with laudable purpose of ensuring the integrity of military honors by punishing those who make such false representations. Unfortunately, the scope of the law was recently found by the Supreme Court to be unconstitutional as an abridgment of the First Amendment's right to speech, because the First Amendment even protects despicable speech. Justice Kennedy, however, writing for the Court, set out certain guidelines that Congress could follow in remedying the statute's constitutional flaw. He wrote, "Where false claims are made to effect a fraud or secure monies or other valuable considerations, say offers of employment, it is well established that the government may restrict speech without confronting the First Amendment." And so, as reported by the Judiciary Committee, this bill adheres to the suggestion this suggested construct by amending the current law to prohibit individuals from fraudulently representing themselves as recipients of these honors in order to obtain money, property, or other tangible benefits. This will actually cover most of the incidences of false claims. As a result, this measure will, in full compliance with the Constitution, ensure that no one will financially benefit or receive other tangible rewards from falsely representing that they have been awarded these honors, and this will cover all of the despicable cases of false claims that the Constitution will allow. Under H.R. 1775 will protect the honor and integrity of our nation's military medals and decorations, as well as respect the rights accorded to Americans under the First Amendment. Accordingly, Mr. Speaker, I urge my colleagues to support the legislation, and I reserve the balance of my time.
Gentleman reserves. The gentleman from Texas.
Mr. Speaker, I will yield as much time as he might consume to the gentleman from Arkansas, Mr. Griffin, who is an active member of the Judiciary Committee.
The gentleman is recognized.
Thank you, Mr. Chairman. Thank you, Mr. Speaker. I rise today in support of H.R. 1775, the Stolen Valor Act of 2011, and urge its passage. I would like to thank Congressman Joe Heck for his leadership on this issue, as well as Judiciary Committee Chairman Smith. Also, Ranking Member Conyers for their bipartisan cooperation passing this bill out of committee. As a proud co-sponsor of the Stolen Valor Act, I offered a substitute amendment during committee consideration in response to the recent Supreme Court decision in U.S. v. Alvarez. The Court instructed that, however despicable, a false claim about receiving a military award is protected by the First Amendment. The substitute amendment, which was adopted unanimously by the Judiciary Committee on August 1, 2012, incorporates the Supreme Court's opinion and the recommendations in Alvarez. The bill we consider today ensures that the Medal of Honor, Purple Heart, and other military awards will be protected from fraud, and that those who make false claims of military service or awards will face criminal penalties. I believe that protecting the integrity and valor of American service members who have distinguished themselves in defense of this nation is critically important. We must ensure that the Medal of Honor and other military awards are protected from fraud and the Stolen Valor Act helps in that effort. Thank you, and I yield back the balance of my time.
Gentleman yields back. Gentleman from Virginia.
Mr. Speaker, I yield back the balance of my time.
Gentleman from Texas.
And, Mr. Speaker, I yield back the balance of our time as well.
Gentleman yields back. The question is, will the House suspend the rules and pass H.R. 1775 as amended? Those in favor say aye. Aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules.
Mr. Speaker, I ask for the yeas and nays.
The yeas and nays are requested. All those in favor of taking this vote by the yeas and nays will rise and remain standing until counted. Sufficient number having arisen, the yeas and nays are ordered pursuant to Clause 8 of Rule 20. Further proceedings on this question will be postponed. For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 6215 to amend the Trademark Act of 1946 to correct an error in the provisions related to remedies for dilution as amended.
The clerk will report the title of the bill.
H.R. 6215, a bill to amend the Trademark Act of 1946 to correct an error in the provisions relating to remedies for dilution.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, gentleman from North Carolina, Mr. Watts, each will control 20 minutes. The Chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 6215 as amended, currently under consideration.
Without objection.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, the purpose of the Federal Trademark Dilution Act of 1995 is to protect famous trademarks from uses that blur the distinctiveness of the trademark or tarnish or disparage it. Dilution does not rely upon the standard test of infringement, that is, likelihood of confusion, deception, or mistake. Rather, it applies when the unauthorized use of a famous trademark reduces the public's perception that the trademark signifies something unique, singular, or particular. Dilution can result in the loss of the trademark's distinctiveness and possibly the owner's rights in it. Congress enacted amendments to the original dilution statute in 2006. Last year, 2 law professors discovered a technical problem with one of the 2006 changes. During Senate consideration of the House bill, the section that provides a federal registration defense to a dilution action was reorganized. This produced an unexpected and unintended change to the law. As originally drafted in the House, the provision was designed to encourage federal registration of trademarks. This is a worthy policy goal that prevents state laws from interfering with federally protected trademarks and ensures that registered trademarks are protected nationwide. The House version promoted this goal and barred a state action for dilution against a federally registered trademark. However, the Senate reformatted the House text in such a way as to create a bar against state action for dilution as well as a state or federal action based on a claim of actual or likely damage or harm to the distinctiveness or reputation of a trademark. This means the federal registration defense is available to both state and federal dilution claims. Congress did not intend such an outcome. If all dilution claims, including federal claims, are barred by registration, it becomes difficult to cancel a diluting trademark that is registered. This encourages illegitimate trademark holders to register diluting trademarks, which forces legitimate trademark holders to expend greater resources to monitor registrations as well as other trademarks being used in commerce. That is why I introduced H.R. 6215 to amend the Federal Trademark Dilution Act. This bill simply reformats the affected provision to clarify that federal registration only constitutes a complete bar to a state claim based on dilution or actual or likely damage or harm to the distinctiveness or reputation of a trademark. The change applies prospectively. This bill ensures that the trademark community is protected from those who seek to use this loophole as a way to disparage legitimate trademarks and cost their owners time and money. The only change to the bill as reported is a technical correction to a boilerplate reference regarding the date of enactment of the Trademark Act of 1946. The reported version inaccurately identifies the date of enactment as July 6, 1946. The correct date is July 5, 1946. I urge my colleagues to support H.R. 6215, and I'll reserve the balance of my time.
Gentleman reserves. The gentleman from North Carolina.
Speaker, I yield myself as much time as I may consume.
Gentleman's recognized.
Mr. Speaker, I rise in support of H.R. 6215, which is necessary to correct a technical error in the Trademark Dilution Revision Act of 2006 that inadvertently allowed the registration of a federal trademark to be a complete bar to federal trademark dilution claims. The concept of dilution was initially a creature of state law. Massachusetts was the first state to enact a dilution statute in 1947. The purpose of the dilution law is to protect the value and uniqueness of the plaintiff's trademark without requiring evidence about the likelihood of confusion. Over 50 years after the passage of the Massachusetts statute, the 1996 Federal Trademark Dilution Act provided nationwide injunctive relief, quote, against a use that causes dilution of the distinctive quality of the famous trademark, close quote. In 2003, however, the Supreme Court in Mosley v. Victoria's Secret Catalog, Inc., considered the question of whether objective proof of actual injury to the economic value of a famous mark, that is, actual dilution, is required to obtain relief under Federal Trademark Dilution Act. The Court decided that evidence of actual dilution was required, not simply a showing of likely dilution. The Trademark Dilution Revision Act of 2006 amended the law in an attempt to reverse the Victoria's Secret decision and to expand the scope of state dilution claims banned under the federal statute. During consideration of the Trademark Dilution Revision Act, however, the provision allowing a federal registration defense to dilution claims brought under state law was reorganized in such a way as to result in an unintended substantive change in the provision. As a result, the federal registration defense is available not only against state dilution claims, but also against federal dilution claims. The legislative history makes clear that Congress did not intend to allow a federal trademark registration to bar a federal dilution claim. H.R. 6215 corrects this error and has broad support in intellectual property community and bipartisan support on the Judiciary Committee. I urge my colleagues to support the legislation which ensures that the will of the Congress as originally intended is not undermined by an inadvertent drafting error, and I reserve the balance of my time.
Gentleman reserves. The gentleman from Texas.
Mr. Speaker, I'll yield back the balance of my time.
And I will yield back the balance of my time, Mr. All time yielded back. The question, will the House suspend the rules and pass H.R. 6215 as amended? Those in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being the affirmative, the rules are suspended. The bill is passed, and without objection, the motion to reconsider is laid on the table. For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 6189 to eliminate unnecessary reporting requirements for unfunded programs under the Office of Justice Programs as amended.
The clerk will report the title of the bill.
H.R. 6189, a bill to eliminate unnecessary reporting requirements for unfunded programs under the Office of Justice Programs.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentleman from Michigan, Mr. Conyers, each will control 20 minutes. The Chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 6189 as amended currently under consideration.
Without objection.
And, Mr. Speaker, I yield myself such time as I may consume.
And the gentleman is recognized.
Mr. Speaker, I join the ranking member, Congressman Conyers, in co-sponsoring this common-sense bipartisan bill, the Reporting Efficiency Improvement Act, and I thank him for introducing this legislation. The Government Performance and Results Modernization Act of 2010 requires federal agencies to identify reports that may be outdated or duplicative. Then the executive branch must consult with Congress to determine if these reports can be eliminated. Here the administration suggests that Congress repeal the 2 reports eliminated by this bill. Both of these reports are prepared by the Office of Justice Programs and the Department of Justice, but the underlying grant programs have not been funded by Congress for many years. Adopting this common sense bill is a simple step that Congress can take to help federal agencies work more efficiently. I hope this bill sets a precedent for many similar bills in the future. I again thank Mr. Conyers for his initiative on this issue. I urge my colleagues to support this bill, and I'll reserve the balance of my time.
The gentleman reserves the balance. Mr. Conyers.
Mr. Speaker, I yield myself as much time as I may consume.
The gentleman is recognized.
H.R. 6189, Reporting Efficiency Improvement Act, eliminates 2 reporting requirements that the Department of Justice deems no longer needy or useful to the Congress. Under the Government Performance and Results Modernization Act, the Department of Justice conducts an annual review of statutory reporting requirements that are outdated, duplicative, or otherwise no longer useful. In this review, the Department identified 2 reports that are the subject of the bill before us now. The first of the 2 stem from the DNA Analysis Backlog Elimination Act, under which the Attorney General is required to report to Congress on various grants made to states to perform DNA analysis. Because Congress has not appropriated any funding for these specific grants since fiscal year 2003, this statutory reporting requirement has been obsolete for almost a decade. The second report is based on the Police Corps Act, originally a part of the Violent Crime Control Act of 1994. The Director of the Office of the Police Corps is required to make an annual report to Congress on the program's status. However, Congress hasn't appropriated any funds for the office since fiscal year 2005. So H.R. 6189 is a simple cleanup of the federal code. There's no need to have these reporting requirements on the books if there's no activity for the Department of Justice or the Office of Justice Programs to report, and none planned at any time in the near future. It's important to note that this legislation doesn't make changes to the relevant programs. It merely eliminates discrete reporting requirements that are no longer useful. I want to thank Lamar Smith, the chairman of the Judiciary Committee, for his support and eagerness in moving this legislation through the committee. And so I urge my colleagues to support the measure. I reserve the balance of my time, and having no other requests for additional speakers on this side, I yield back the balance of my time.
Gentleman yields back.
And Mr. Chairman, Mr. Speaker, I first want to thank the ranking member, the gentleman from Michigan, Mr. Conyers, for his nice comments, and I'll yield back the balance of my time as well.
Gentleman yields back. The question is, will the House suspend the rules and pass H.R. 6189 as amended? Those in favor say aye. Those opposed, no. In the opinion of the Chair, 2/3 being in the affirmative, the rules are suspended, the bill is passed, And without objection, the motion to reconsider is laid on the table. For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 6080 to make improvements in the enactment of Title 41 United States Code into a positive law title and to improve the code.
The clerk will report the title of the bill.
House Calendar Number 159, H.R. 6080, a bill to make improvements in the enactment of Title 41 United States Code into a positive law title and to improve the code.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentlewoman from California, Ms. Lofgren, each will control 20 minutes. The chair recognizes the gentleman from Texas.
Okay. Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 6080 currently under consideration.
Without objection.
And, Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, the rules of the House entrust to the Judiciary Committee the responsibilities of revision and codification of the statutes of the United States. This power does not give our committee substantive legislative jurisdiction over all areas of law. It merely confers the authority to organize duly enacted laws into an efficient codification system. The nonpartisan Office of Law Revision Counsel is responsible for properly codifying public laws into titles and sections of the United States Code. From time to time, that office provides the Judiciary Committee with advice as to how to enact a more user-friendly and cohesive statutory system. This spring, Republican and Democratic committee staff worked cooperatively with the Office of Law Revision Counsel to develop H.R. 6080. The bill makes technical improvements to Title 41 of the United States Code, which contains federal laws that govern public contracts. The bill makes no changes to substantive law. I encourage my colleagues to support this bill, and I'll yield back the balance of my time.
You yield back the balance of this time. The gentlelady from California.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
Gentlelady is recognized.
Mr. Speaker, I'm pleased to join my colleague, Judiciary Committee Chairman Lamar Smith, in bringing this bill to the floor. This is a common-sense bill. As has been noted, it makes technical revisions to bipartisan legislation enacted during the 111th Congress that created the new Title 41 of the USC, which pertains to public contracts. This bill was prepared by the Office of Law Revision Counsel as part of its ongoing responsibility to draft and submit to the Committee on the Judiciary one title at a time, a complete compilation, restatement, and revision of the general and permanent laws of the United States. The bill makes conforming amendments to the laws contained in Title 41, corrects references that require more particular reference. In addition, the bill omits references to outdated or repealed laws, makes clarifying revisions to Section Title 41 that do not provide meanings for particular words for the purpose of clarity, and corrects to cross-references to public laws that may have been erroneously concluded. The bill is not intended to make any substantive changes to the law. As is typical with the codification process, a number of non-substantive revisions are made, including the revision of sections into a more coherent overall structure, but these changes, as I've said, are not intended to have any substantive effect. I urge my colleagues to support this legislation, and I would like to take this opportunity to thank the Office of the Law Revision Counsel for its good work. This makes a practice of law more coherent in the United States. We have no speakers, and so I would yield back the balance of my time.
Gentlelady yields back. The question is, will the House suspend the rules and pass H.R. 6080? Those in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules are suspended. The bill is passed. And without objection, the motion to reconsider is laid on the table. For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass S. 3245, a bill to extend by 3 years the authorization of the EB-5 Regional Center Program, the E-Verify Program, and the Special Immigrant Non-Minister Religious Worker Program and the Conrad State 30J1 Visa Waiver Program.
Clerk will report the title of the bill.
Senate 3245, an act to extend by 3 years the authorization of the EB-5 Regional Center Program, the E-Verify Program, the Special Immigrant Non-Minister Religious Worker Program, and the Conrad State 30J1 Visa Waiver Program.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentlewoman from California, Ms. Lofgren, each will control 20 minutes. The chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on S. 3245 currently under consideration.
Without objection.
And, Mr. Speaker, I yield myself such time as I may consume.
And the gentleman is recognized.
Mr. Speaker, first of all, I'd like to thank the Senate Judiciary Committee Chairman and Ranking Member for introducing this legislation and for working with me to help ensure that 4 key immigration-related programs do not expire at the end of this month. This Congress must ensure there is a national business climate that fosters the ability of private enterprise to create jobs for Americans and legal workers. S. 3245, which extends for 3 years the E-Verify, EB-5 Regional Center Pilot, the Conrad 30J1 Visa Waiver, and the Special Immigrant Non-Minister Religious Worker Programs, helps achieve this goal in several ways. First, the E-Verify program allows employers to electronically verify that newly hired employees are authorized to work in the United States. The program is free, quick, and easy to use. Nearly 400,000 American employers use E-Verify, and over 1,000 new businesses sign up for it every week. The American public overwhelmingly supports E-Verify. Last year, a Rasmussen poll found that 82% of likely voters, quote, think businesses should be required to use the federal government's E-Verify system to determine if a potential employee is in the country legally, end quote. E-Verify has also received bipartisan congressional support in the past. In 2008, the House passed a 5-year extension of E-Verify by a vote of 407 to 2. And in 2009, the Senate passed a permanent E-Verify extension by voice vote. Ensuring that businesses have access to E-Verify will help preserve jobs for the 23 million Americans who are currently unemployed or looking for full-time work. The Investor Visa program also helps create jobs for Americans. Under this program, 10,000 immigrants can receive permanent residence each year if they engage in a new commercial enterprise, invest between $500,000 and $1 million in the business, and see that it creates 10 full-time jobs for American workers. The Regional Center Pilot Project, which is almost 2 decades old, has reinvigorated the Investor Visa program. Investment through a regional center is especially attractive to potential investors because they are relieved of the responsibility of running a new business. They can also count indirect job creation towards the job creation requirement. Most Investor Visa petitions now involve regional centers. It appears that investors may feel more confident about a regional center that is operated through a state or city government. In these hard economic times, many state and local governments have turned to regional centers as a method of generating economic growth. The Association to Invest in the United States of America has estimated the Regional Center program has created or saved over 65,000 jobs in the U.S. and has led to the investment of over $3 billion in the U.S. economy. S. 3245 also extends for 3 years a program that has successfully brought needed doctors to medically underserved areas in the U.S. This program was designed by Senator Kent Conrad. It allows foreign doctors who have been in the U.S. on exchange programs to stay at the conclusion of their residencies if they agree to practice medicine for at least 3 years in health professional shortage areas. This is a valuable provision, and I support its reauthorization. Finally, S. 3245 extends the Special Immigrant Non-Minister Religious Worker Program. Under this program, 5,000 immigrant visas can be issued to non-minister individuals who have been members of the denomination and have worked in the capacity for which they are applying for at least the 2 years immediately following the visa application. Historically, the program has been plagued by fraud, but the Bush administration took steps to help prevent much of the fraud, and now many churches and religious organizations in the United States rely on these immigrant non-ministers. I look forward to making statutory changes aimed at even more fraud prevention and support the program's extension. Again, I want to thank Senator Leahy and Senator Grassley for their leadership on this bill. All four of these programs are important, and I urge my colleagues to support S. 3245. And I'll reserve the balance of my time.
Gentleman reserves. The gentlelady from California.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
Gentlelady is recognized.
Mr. Speaker, I do rise in strong support of this bill. Specifically, this bill extends until September 30th, 2015, these 4 long-standing immigration programs that are set to expire otherwise at the end of this month. They're valuable programs, and they serve different purposes. The Special Immigrant Non-Minister Religious Worker Program allows religious workers to enter the United States to do important work. There's 5,000 religious workers eligible for these visas each year, and they're called to a vocation or are in a traditional religious occupation with a bona fide nonprofit religious organization. They're missionaries, counselors, instructors, pastoral care providers, and they really help our country. The second program, the Conrad J. Waiver, helps medically underserved communities attract highly skilled physicians. This program literally provides a lifeline for communities that desperately need doctors who receive their medical training in the United States, and it's absolutely necessary that this program continue to exist so that states can attract medical talent and can keep the doors of small-town clinics open. The third program, the EB-5 Immigrant Investor Pilot Program, allocates 3,000 out of the EB-5 category's 10,000 visas each year for EB-5 investors who invest in these designated regional centers. Now, this pilot program is important to our nation's economy as it represents actually billions of dollars in aggregate immigrant investment and creates more than 20,000 new direct and indirect jobs each year. The final program that would be extended under the bill is E-Verify, the basic pilot program first authorized in 1996. Now, Chairman Smith and I disagree on how effective this bill is. I don't believe it's ready for mandatory nationwide use because of errors in the system and, more broadly, major dysfunctions in our immigration system. But that doesn't mean I disagree that this program should be extended. I do. This program is voluntary, and by extending the E-Verify program as it currently exists, it will provide Congress additional time to work toward improving the program and fixing our nation's immigration laws so that they work for American families, businesses, and the economy as a whole. I should note that this bill received unanimous support in the Senate. Likewise, I hope that all of my colleagues in this chamber will support this bipartisan legislation so that it can be quickly sent to the President's desk for his signature, and I reserve the balance of my time.
Gentlelady reserves. The gentleman from Texas.
And, Mr. Speaker, I'll reserve the balance of my time as well.
Gentleman yields back.
Mr. Speaker, we do have 2 members who would like to address us briefly. I would yield to Mr. Larson for 2 minutes.
Gentleman is recognized for 2 minutes.
Mr. Chair, I rise today in support of 3245, which would in part reauthorize the EB-5 visa program for 3 years. This EB-5 program will create good American jobs. Last year, I worked with Senator Leahy to write H.R. 2972, the Creating American Jobs for Foreign Capital Act. That legislation would have reauthorized EB-5 permanently. While the bill before us today extends the program for only 3 years, it is still an important job creator that we must pass. The program allows qualified foreign investors who invest in the U.S. and create or save at least 10 full-time American jobs to seek U.S. visas. This program brings overseas capital to the U.S. to create jobs for people in my district and across America. There are 2 projects in Everett, Washington currently being financed through the EB-5 program. One is a college building that, if this bill is not passed, our area will lose this building and the opportunities associated with it. The second investment is one for a building housing a regional farmers market, a project that has been in the works and is almost done. This project will help local farmers regionally and create jobs, and if this bill is not passed, again, this project, which is set to be finished soon, cannot be completed and all finance and investments lost. In another part of my district in Whatcom County, the local EB-5 Center has leveraged more than $34 million from immigrant investors to create more than 800 good local jobs. The EB-5 program is a real threefer. It's a win for American workers who benefit from thousands of new jobs. It's a win for the taxpayer because it doesn't add one penny to the national deficit. And third, it helps the U.S. compete on a global scale. The U.S. EB-5 visa program is one in more than 20 similar programs run by other important growing economies like Hong Kong, New Zealand, Australia, and Singapore. Our economy cannot afford to do without these investments or these jobs. If we don't keep this road open for foreign investment into the U.S. open, that investment will choose another country's road. Congress must extend the EB-5 program so we can continue creating new jobs at a time when we need them most. I yield back my time.
Gentleman yields back.
Mr. Chairman, I would yield a minute and a half to the gentleman from Vermont, Mr. Welch.
I thank the gentlelady. I thank the gentleman from Texas. I thank the gentlewoman from California. This is terrific. The EB-5 program works. We're doing it together. We're working with the Senate. We're getting something done. And let me tell you, the place we're getting something done includes the Sugarbush Valley, in the Mad River Valley in Vermont, in the Northeast Kingdom, where we've had, among other jobs created, 2 ski areas that have been able to take advantage of the EB-5 program, get investor money, build the infrastructure that is so essential to the tourist economy that we have in Vermont. So this is a program that works, and it's delightful to me to be able to participate in reinstating this program so that it can continue to help create jobs, promote economic development in my state of Vermont. I thank the gentleman from Texas and the gentlewoman from California for your leadership on this, and the bipartisan team of Senator Leahy and Senator Grassley in the United States Senate. And I yield back.
Yields back. Gentleman from Texas. Reserve.
Thanks.
Mr. Speaker, I'll reserve the balance of my time.
I have no additional speakers, and I would be happy to yield back the balance of my time.
Gentlewoman yields back.
Mr. Speaker, before I yield back the balance of my time, I just want to thank the gentlewoman from California, Ms. Lofgren, for her continued interest in and leadership in the subject of immigration, and I especially appreciate her support of this bill today. I'll yield back the balance of my time.
Gentleman yields back. The question is, will the House suspend the rules and pass Senate Bill 3245? Those in favor say aye. Those opposed say no. In the opinion of the Chair, 2/3 being in the affirmative.
Mr. Speaker, on that I ask for the yeas and nays.
The yeas and nays are requested. All those in favor of taking this vote by the yeas and nays will rise and remain standing until counted. A sufficient number having risen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed. Do you want this or should I? For what purpose does the gentleman from Florida seek recognition?
Mr. Speaker, I move to suspend the rules and pass H.R. 4057 as amended.
Clerk will report the title of the bill.
Union Calendar Number 464, H.R. 4057, a bill to amend Title 38 United States Code to direct the Secretary of Veterans Affairs to develop a comprehensive policy to improve outreach and transparency to veterans and members of the armed forces through the provision of information on institutions of higher learning and for other purposes.
Pursuant to the rule, the gentleman from Florida, Mr. Belarakis, and the gentleman from California, Mr. Filner, will each control 20 minutes. The Chair recognizes the gentleman from Florida.
Thank you, Mr. Speaker. Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include any extraneous material they may have on H.R. 4057 as amended.
Without objection, so ordered.
Mr. Speaker, I yield myself as much time as I may consume.
The gentleman is recognized.
Thank you, Mr. Speaker. Mr. Speaker, H.R. 4057 as amended is another bipartisan product of the Committee on Veterans Affairs work to improve the effectiveness of several different benefits and health programs for veterans. I want to express my appreciation to my good friend, Chairman Miller, and my other good friend, Ranking Member Bob Filner, along with each of the subcommittee chairs, Marlin Stutzman and Anne Marie Burkle, as well as ranking members Bruce Braley and Mike Michaud, for bringing, of course, these provisions to the full committee and to the floor today. The bill has 5 major sections, Mr. Speaker. Section 1 reflects a slightly modified version of the original text of my bill, H.R. 4057, which I introduced in February. This legislation would improve the ability of GI Bill users to choose the school that best meets their educational needs. As we commemorate September 11th today, it is appropriate that this Congress help this generation of post-9/11 veterans make informed choices about using their educational benefits. Specifically, this legislation will require the VA to create a comprehensive policy that would meet this goal by informing veterans about their eligibility for educational counseling, creating a centralized complaint database on schools, requiring state approving agencies to better communicate with accrediting agencies, require VA to link to certain performance-related data points on the College Navigator and other appropriate websites, and identifying commercially off-the-shelf available software that would assist students in choosing a school and software that would evaluate their readiness to attend post-secondary education. I want to thank the veteran service organizations and higher education associations for their support of this section and providing great feedback on ways to improve this bill. Section 2 contains provisions originally introduced by Congressman Stivers and my friend from across the aisle, Congressman Tim Walz, to require states to take military training into account in awarding licenses to work as medical technicians and other trades. I thank both Mr. Stivers, another good friend of mine, and Mr. Walz for their work on these provisions that will speed up service members' transition to civilian life. Section 3 contains a provision introduced by Congressman David McKinley, which would require per diem payment recipients under VA Homeless Grant and Per Diem Program to certify compliance with the Life Safety Code or the International Fire Code and other relevant fire safety and building codes. It would also require VA to include an accounting and evaluation of the safety and accessibility of facilities used to provide programs for homeless veterans and the annual report on assistance to homeless veterans. I am grateful for Mr. McKinley's advocacy on behalf of our homeless veterans, and I thank him for his hard work to ensure that they are cared for in a safe and secure environment. Section 4, which incorporates language originally introduced by Representative Aiken, would direct the VA to establish and maintain an open burn pit registry for veterans, very important, veterans of Iraq and Afghanistan who may have been exposed to toxic chemicals and fumes caused by open burn pits during deployment. It would require VA to develop a public information campaign to inform eligible veterans of the registry and periodically notify them of significant developments in the study and treatment of conditions associated with burn pit exposure. It would also direct the VA to contract with an independent scientific organization to develop a report on the effectiveness of actions taken to collect and maintain information on the health effects of burn pit exposure and submit the completed report to Congress. Many of our service members and veterans have returned from Iraq and Afghanistan with grave concerns about the possible long-term health effects of burn pit exposure. With this provision, I hope we will move one step closer to providing them answers which may lead to getting them more effective health care. Finally, Section 5, which incorporates language offered by Mr. Stearns, a good friend of mine from the state of Florida, will limit the total amount of bonuses paid to senior VA employees to $1 million for fiscal years 2013 to 2017. On average, over the last several years, VA paid nearly $4 million a year to senior executives who are already paid very well. In a tight fiscal climate when so many improvements are needed for veterans, we must prioritize every dollar. Extravagant executive bonuses ought to be the least of our priorities, and I'm pleased this section would recognize that reality. Mr. Speaker, I would also note that the costs of these sections are fully paid for. I encourage all members to support this bill and to reserve the balance of my time. Thank you, Mr.
reserves.
Speaker.
Gentleman from California.
Thanks, Chair. And I ask for